Hey, good morning, everybody. Welcome back to Law and Legitimacy. It's Tuesday in a week that already seems too long. Anyhow, we're back. Lots going on in the news today, maybe. And certainly some stuff in the Donald Trump trial. As expected, Judge Merchan held Donald in contempt.
Hey, it's May 1st. Can you believe that?
Mayday, Mayday, Mayday.
It is May 1. We are a mere 5 días de Cinco de Mayo, you know? Cinco de Drinko. Anyway.
Well,
good morning, Norm.
Good morning. I'm sorry to jump right into it, Mike. In my sort of narcissistic fascination with the news. How's the weather?
I'm trying to stall you because I'm trying to stall you because I'm trying to let everybody kind of file in here, get all the Rumblians into the chat over there. Do my dizzle over there on the thumbnail and stuff like that, since Rumble lets us pay for it but doesn't give us tools that are anywhere close to what YouTube affords. So anyway, what you got?
Right, so, as expected, Judge Merchan fined Donald Trump, holding him in criminal contempt for 9 of 10 violations the people of New York sought for Trump's extrajudicial, that is, out of court, statements about witnesses and trial participants and jurors. Judge Merchan warned Trump that $1,000 per violation was the statutory maximum in New York. That's you, Donald. He warned you that $1,000 is the statutory maximum, sir, that I can impose on you, sir. And I realize that that is a de minimis sum given your wealth. Understand this, Mr. Trump, that the court has at its disposal the ability to incarcerate you as a sanction if this conduct continues. I'm imagining Merchan looking this man in the eye and confronting him with the authority of the court, saying, look, you are an individual facing charges that you may or may not agree with. You may refer to these charges as political, but in this court, you have a legal problem. And that legal problem is the state of New York is seeking to incarcerate you or seeking to convict you for fraud. You're here to defend those allegations in a courtroom. This isn't a political stage. This isn't reality TV. I'm not a prop on The Apprentice. You are a citizen standing before the bar at a court of law. And if you cannot comport yourself as such a citizen, if you cannot obey the rules of this court will have no alternative but to create a sanction, because I will not permit you to ignore, flout, ridicule, or otherwise make light of the rules of this court. Do we understand one another, Mr. Trump? And what's Donald going to say in there? Yeah, it's a kangaroo court, Judge.
Whatever, Jet. Whatever.
I don't know what'll happen. It really is mind-bending. It seems to me that the court could easily incarcerate Trump if he doesn't stop talking. And I don't see Trump stopping. I don't see a stoppage to Trump talking. There's a tongue twister. I don't see a stoppage to Trump talking. Say that quickly, Mike.
I don't see Trump stopping talking. Trump stopping
talking, a stoppage to talking, whatever it is. So I think it's an uneasy standoff that tiptoes close to the line of the Supreme Court argument on the scope of executive privilege. I mean, clearly there is no privilege if you're not executive privilege, if you're not the chief executive, and he's not. He's running for that office. So we could be at a point we've not been at in 100 years in this country relatively soon. If Trump keeps talking and Merchan locks him up, we're going to have a guy running for president from behind bars. Unlike Eugene Debs, who had a platform that was principled and easily to understand, Trump's platform is less easy to understand, at least for me. It seems more personality driven. So, those of you who are watching the stream know we have a fascination with First Amendment law. And so you may think, well, what about his right to speak? What about a candidate's right to speak? And is that being impinged? Well, everybody has a right to speak. The question is, can you speak without consequences? And in this case, because Trump is under the jurisdiction of the court, and the court has an inherent supervisory authority to see that justice is done, it's possible that the court could easily incarcerate him without violating his First Amendment rights, because First Amendment rights always bend to reasonable time, place, and manner restrictions, especially when a speaker is using speech in a public forum. So in this case, the court room is a public forum where justice is sought by the people of New York against Donald Trump. And I could imagine a court saying that while Donald Trump has the First Amendment right to say whatever he likes as a political candidate, Judge Merchan has a parallel responsibility to see that justice is done in the court, and that in so doing, he can place reasonable time, place, and manner restrictions on Donald Trump's speech. In a progressive discipline sort of regime, Trump has taken aim at pretrial, with his pretrial comments at trial witnesses in possible derogation. That is, he may be potentially undermining the fair trial rights of participants in New York State. It's a bad look. But I think if I'm an appellate court justice, and this comes to me on emergency relief, I certainly would respect and seek to vindicate Trump's right to say what he likes when he likes. But I could not and would not ignore Merchan's responsibility to assure that there be a fair trial. And in this case, the compromise position might well be that there be a reasonable time, place, and manner restriction.
Yeah,
Dawn, am I living in a hallucination?
I love that. She's asking if she's insane, and I was asking myself that this morning. I don't know, at least what time is it? 8:08. So I mean, a few times.
While I'm talking or earlier?
No, I mean, I was up fairly early this morning. Didn't mean to click on that one. Choosy Heretics, you were here yesterday. I'm not sure. Maybe we'll get to the Jesuitism stuff at some point, but you're talking to a fairly ignorant member of the law-abiding public when it comes to, I guess, whatever angle you've got there. Not to distract, though, Norm. What I've got on the screen here is language from the order. Judge Merchan gave his legal conclusion, and just so we're clear, $1,000 fine for each of the 9 posts that he found violated the gag order, and as well as an order, injunctive relief or equitable relief, whatever we want to call it here, to remove such posts, right? So $9,000 in the aggregate is the fine, and the behavior that Trump must abide is deleting those posts. In response to what you were just discussing, Norm, in terms of a defendant's right, First Amendment rights, he says this, and I'm not going to read the whole thing, but it is at least helpful to understand what the ideal standard is. Whether we agree if this is gaslighting remains to be seen. But here it is at the very least. Quote, at the same time, this court is keenly aware of and protective of defendant's First Amendment rights, particularly given his candidacy for the office of President of the United States. It is critically important that defendant's legitimate free speech rights not be curtailed, that he be able to fully campaign for the office which he seeks, and that he be able to respond and defend himself against political attacks. For that reason, this court exercised discretion when it crafted the expanded order and delayed issuing it until the eve of trial. The order is narrowly tailored to prevent risk to the fair administration of justice, and it clearly and unambiguously identifies the limited way in which defendant's speech is restricted. It is of utmost importance to this court that the expanded order not be used as a sword instead of a shield by potential witnesses. Consideration of such usage will be weighed by this court when ruling on the willfulness of any future claims of alleged violations of the expanded order, as well as when determining appropriate punishment, if any.
I mean, again, I'm looking at the chats on the, I guess it's YouTube, and some people seem to be surprised by the tack that we're taking here. Because I think there is a contingent of viewers and listeners here who regards the Trump prosecution as purely political in motivation, and therefore a purely political response by Donald is appropriate in any context. That is one way to look at this, but it diminishes the institutional authority of the courts. And courts are where we go to resolve disputes between the people and individuals. The people's motives in bringing the case is a very interesting question. It commonly happens at trial, and it has happened to me, that when I seek to introduce evidence about the state's motive to prosecute, a judge will say the state isn't on trial, or say in New York, the people aren't on trial, the state isn't on trial here. And I commonly respond by saying, of course it is. It chose this fight, and motives are never collateral. A party's motive in doing something in a courtroom is never collateral. And therefore, the motives of the state in bringing in the action are not. And then you end up with a really thorny problem. Buckle up, folks. This is going to blow your head open a little bit if you're a regular listener to this show. Abstract nouns don't have motives. The people don't have motives. The state doesn't have motives. There is not a deep state floating out there as an abstract noun that instantiates itself through people and then imposes its will on others. Abstract nouns or legal fictions are things that we use to help organize the world. Whatever state you're in, I challenge you to walk into a public office today and say, I'd like to meet New Mexico. Can you arrange a meeting? I'd like to meet California. Where do I go? I once, in a criminal trial where I wanted to ridicule the state's motives, and I didn't get court permission to do this and caught everybody by surprise, so I got away with it. I stood up during closing argument and I said, ladies and gentlemen, you'll never meet my adversary in this case, the state of Connecticut. All you'll meet are its representatives, and I can't put them on the stand because they're not witnesses. If I could put the state on the stand, though, this is what would happen. I call the state of Connecticut. I walked up to the witness stand. I said, it's so nice to meet you. I've given you so much money over the years. I've got one question for you. What the hell were you thinking when you brought this crazy case? And the jury gasped. The judge looked at me wide-eyed. The prosecutor was in shock. But in the end, the jury acquitted. So we don't, I get troubled. I'm deeply, deeply troubled by the presence of conspiracy theories abounding in our society and the attribution of reality, motive, personality to abstract nouns. I think that does a certain violence. What we have the ability to do is to question individuals who bring their claims and who bring claims on behalf of the state. In a criminal court, most judges do not permit an inquiry into the motives of the individuals who represent the people, and it's a glaring logical gap that is going to make you kind of go cross-eyed when you think about it as I talk about it, because it's goofy. Alvin Bragg is putting on witnesses on behalf of the people, but Alvin chose to bring the case. Alvin is the man in charge. He's the person who, if it's political, made the judgment call to bring this action. He's not going to be a witness, and his motives aren't going to be inquired into. And Mershon is likely to say the people's motives are irrelevant. And therefore, whether this is a political prosecution or not is not a question for the jury. Now, if New York permitted jury nullification, they could argue that it was political, but because I don't think New York does, they won't be able to. So it seems to me that what we have in the Trump prosecution is really heartbreaking and mind twisting, so to speak, because while it may be true that this is a political prosecution in the sense that Alvin chose to do it for reasons related to politics, that's not something the jury is going to be permitted to consider. And, it daunts the people. What is that? It's nothing. It's everything and nothing at once. The caption on this case reads, "The people of New York versus Donald Trump." The people of New York are on their behalf. Mr. Trump is being put through rigors and pains of trial and the potential loss of liberty. And the people of New York will lock him up, but you'll never meet the people. The people is, like the state, a legal fiction, but it's a necessary legal fiction through which we act and have our being. And so in the criminal courts, we've got a real problem in the Donald Trump case. Bragg may be making a political case, but the political consequence of the case he's making is testing the proposition that all individuals are equal under the law, even presidential candidates. And so while Donald Trump as a presidential candidate has a paramount right to speak and to speak about issues of public concern and to criticize public officials and to mobilize voters, he also has a legal responsibility, as does every person in this country, to abide by the rule of law. And because a prosecutor has made a political decision to prosecute Trump, and the jury is not going to be able to inquire about the motivation of the prosecutor, we have a situation where Trump is being tried. He's got to abide by the rules of court. The people of New York, that Alvin Bragg, are entitled to a fair trial. And the result is that there's going to be reasonable time, place, and manner restrictions on what Trump can say about the trial participants. And like it or not, I believe it's appropriate to hold Trump accountable for violating these rules. A $10,000 fine for a man of his stature means nothing. And so if he continues and the court believes that he is in contempt, we could have a historically almost unprecedented event. And that would be a man running for president while behind bars. Now, in the Eugene Debs case, I remind everybody of the Espionage Act in World War I. Debs was a socialist who believed that the war was being organized, waged, and prosecuted on behalf of capitalists at the expense of ordinary people. And so he spoke out against the draft and he spoke out against the war effort. And he was tried and convicted, I believe it was to a 10-year sentence for violations of the Espionage Act. That was a time when the country was deeply divided about our participation in a European conflict. And there were those who felt that it was the patriotic and right thing to do for ideological reasons. Those who felt that it was wrong and destructive of ordinary working men, again, for ideological reasons. And so in terms of a crisis of legitimacy, there were those who had deeply held and contrasting views of government. It was a time of deep conflict about matters of public policy, and those in power had the right to impose their will through the rule of law on others. I think we have a parallel case with respect to Donald Trump. Again, I don't understand always his appeal to voters, but he has it. And so those voters who believe that this is a political prosecution and illegitimate will be outraged by Donald's incarceration. Others will view that the incarceration is a consequence of his own conduct that he brought on himself by his inability to speak. I think Merchan is doing a credible job of trying to enforce the rules of court while remaining aware simultaneously of the First Amendment and his requirement to see that justice is done. So, let's stay tuned.
So I want to put this on the screen before we move away from this story, and I want to take this opportunity to just, refresh everybody's recollection as to Jackson Barrett's comments over on Rumble, and I think his and my meeting of the minds with respect to this concept that we are now calling false authentication of narratives through the courts, right? Using the judiciary as sort of a justice factory, as it were, but at least temporarily using the bench as a way to authenticate false narratives. And I think, Norm, the easiest thing I have to reference there for our common common reference is the J6 committee report, right? And what made its way into that. But I want to read this really quickly so that we can kind of put some punctuation on this sentence and move on to something perhaps even more controversial than this, if there is something. In the order for the $1,000 per instance, Judge Merchan starts citing the legal standard for the punishment of $1,000. And he says, quote, while $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those instances where the contemner can easily afford such a fine. What an interesting word. In those circumstances, it would be preferable if the court could impose a fine more commensurate with the wealth of the contemner. In some cases, that might be a $2,500 fine. In other cases, it might be a fine of $150,000. Because this court is not cloaked with such discretion, it must therefore consider whether in some instances jail may be a necessary punishment.
Well, and a little insight into a flat tax versus a progressive tax. When it comes to taxation, you pay a progressive income tax based on your wealth. When it comes to a fine, it's a flat fine. And what the court's saying here is it may not be enough. I mean, as we move on, I'm looking at the comments, and the court can punt itself. The court likes to think it has rights. Yada yada yada. Look, I think courts are important, and I think when you place yourself outside the regulation of the courts and call the courts nothing but a gang with wearing robes with gavels instead of guns and gang bangers, meaning marshals, to impose their will, you be careful what you wish for, because when your landlord tries to throw you out, you're going to go to that same court to vindicate your rights. When somebody gets in a car accident with you, you're going to go to those same courts to try to get yourself justice or try to get yourself compensation. If you really are going to pretend to live outside the law, try a thought experiment one day for 24 hours and see how well your life works during that period. My view is it won't work very well, and there's a certain element of hypocrisy in calling the courts, a fraud. While relying on the shelter that the rule of law protects. So, I mean, I think, Donald Trump has put himself in the middle of this problem. And I think he becomes a focal point for discussion about the rule of law. Thank you, Donald. Let's move into another speech-related topic. We've been trying to get to this topic for a couple days, and we just can't seem to focus on it because there's so much else going on. But it's the topic of hate speech. Regular listeners know that this is a First Amendment oriented broadcast, and that generally we've taken a strong libertarian view. That is, the government is an artifice to protect the rights of the people, and among those rights is the First Amendment. And therefore, when the First Amendment says Congress shall make no law, and Congress now means any public entity. Hugo Black's position, a former justice of the Supreme Court, was those words meant exactly what they say. Of course, that's not the way the law has evolved. There are exceptions to what can be said now. You don't have a right to conspire by your speech to engage in a crime. You don't have a right to use fighting words, to walk into somebody and up to somebody and threaten to kick the snot out of them with impunity. You can't say that with impunity. You don't have a right to engage in incitement to say to others, go burn that building down, go do it now. You don't have a right to engage in true threats, that is, putting someone in imminent fear for their safety or welfare or well-being. You don't have a right to defame other people, that is, to make statements that undermine their reputation. You don't have a right to engage in unfair business competition through your speech by engaging in fraudulent conduct, and the list goes on. European countries have experimented, I'm aware, although I'm no scholar in this area, with limitations on other speech. Oh, and of course, the classic example is pornographic, child pornography. We've placed a bright line limit and say that there are limits on your expressive activity with respect to children. You can't publish, for example, pictures of nude children unless they have some sort redeeming artistic, philosophic, social, or scientific value, but things that are done simply for a lurid or sexual purpose are not permitted. Is it not, the United States lacks a hate speech exception to the right to freedom of speech. European countries have it. I've predicted for a number of years that soon the United States would soon contemplate a hate speech restriction. And one of the reasons I got involved in the Alex Jones case, it's been five long years, is I thought he might be the guy that would serve as that focal point. It appears not. Now a new set of issues are percolating. And this again may be but a brief episode in American history, but it may not. And I'm talking about the unrest on campuses right now as regards the Israel-Palestine or Palestinian conflict. And so on certain campuses, some folks have been making extremely hostile comments about Jewish students, kill all the Jews or words to that effect. Arguably, that utterance in and of itself is protected speech. It's an opinion. For example, in Germany, it's against the law to be a Holocaust denier. It's not against the law here. I think that it's probably, I don't think it's against the law to say, let's kill all the Jews. However, when those words escape my lips, I see no redeeming social value in that. And they sound chilling, and I feel embarrassed for saying it and repeating it. And so I begin to see, at least in my mind, a justification under law for a hate speech restriction. Is it easier to say, I have loved ones who are Jewish, and the idea that anyone would utter, let's kill them, is to me close to fighting words, is to me close to incitement to do harm to those that I love, is to me close to a true threat, because it places them in imminent fear for their safety in public when they go to places where such words are uttered. The New York Times front page this morning talks about an interesting experience at Columbia's campus. I realize campus protests may have been cleared out, but according to recent news, but the news as it went to print last night in New York was that there were tent cities put up in honor of Palestinians. And when Jewish students entered, they were surrounded and said, we have Zionists who have entered the camp. Zionists who have entered the camp. Walk and take a step forward so that we can start to push them out of the camp. These are people who are being singled out and stigmatized because of their identity. And so I begin to think that maybe there is a legal justification for a limitation on hate speech, and that it would look something like the justification for limiting obscenity. Some speech simply has no redeeming literary, social, cultural, artistic, or political value. Some speech is expressive in the extreme and expressive in a way that is threatening to others, and that's hate speech. Walking through a Muslim neighborhood saying, let's kill all the Muslims. I mean, that's just not going to promote a sense of community. And so I'm announcing what is probably a 180-degree turn from where I was 5 years ago. Because 5 years ago, I would have said, I would have been an absolutist. And, I would have said that there is no justification under any circumstances for ever imposing limitations on hate speech. Today, I'm not so sure, because I do think that speech is a public act, and there is some responsibility to foster a sense of community under the rule of law. And I find that while I find myself being somewhat hypocritical as I make this transition from one position to another. But I believe that there is justification for a serious effort to come up with a legal standard to evaluate and potentially penalize hate speech. And I don't know what that legal standard will be. This is why when legal doctrines are announced in the court, you start with a general proposition and then have decades of decisions applying and flushing out the standards. Maury says, no, Norm, I have no responsibility for how you take things. And your feelings are limited. My speech isn't limited by your feelings. Yeah, you're absolutely right. And, but if I sat next to you, I'm Greek, by the way. If I sat next to you in a restaurant and you announced to the waiter, I think it's time to kill all the Greeks, and you glared at me, you would certainly be within your rights to do that. But Maury, I don't know you or your ethnicity. I'm going to assume you're Scottish just for purposes of advancing the discussion. Yes, I think it is time to kill all the Scots. We should drive a stake through their hearts. This sort of, realistically, we would leave one another's presence and we would go in separate directions after making those utterances, because we would have made one another uncomfortable with that speech, or we would have stood our ground and come to the point perhaps of blows. But I'm just not sure that that's the solution. I'm not sure that driving us into separate camps and separate silos is the solution. And I don't, Maury, have any idea how to create such a standard. I really don't. But I think it's time to have the debate. And when in my free time, will be looking for ways to advance that.
Yeah, you've certainly come I'm surprised to hear you saying these things, and perhaps it is more of the thought that you expressed at the front end of that why this hits so close to home for you. I can appreciate and respect that. But you sound, I think I'm going to sound a little bit like you when I was giving my views on the issue of TikTok, right? And sort of, my thought that social media is a drug in effect, and to that end should be inaccessible to those under a certain age. I think the algorithms are primarily responsible for what we're seeing on college campuses, and I've been consistent with that. I've been very clear that even from the moment that October 7th occurred and the response to that was what it was, and we began seeing things, sort of simmering all over the country in various state houses and calls at local committee meetings and whatnot to call for a ceasefire. I think I said on this stream that we're not in control of how this is going to metastasize, because we're not in control of the algorithm. And what we're seeing right now is that TikTok is not being banned because social media has some sort of deleterious or harmful effect or otherwise abrogates personal accountability, because people are just kind of taking as given whatever they're shown in a feed and where they're directed, and they're consuming information that's prioritized specifically for them, advancing a certain narrative that they might not even be conscious of. I'm troubled by what you're saying, because it's not indistinguishable from the chat, right? I think everybody talking about the fact that, who gets to regulate that, who's responsible for enforcing it, who's to say what culture should be or is. I think that I've been consistent on this, on the issue of social media, the inorganic nature of these protests. Even though they seem organic, it's not. And I think that this is a 2.0 of what we saw with the BLM protests in the summer of 2020. And I also am saying, we're having this conversation. Some of the people in the stream have talked about this being a bit of a distraction. I don't disagree with that. I think that we've also seen Congress vote to pass the bill that quote unquote bans TikTok or forces the sale. But what that bill actually does, Norm, you and I haven't even discussed on this stream, and it goes far, 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 far beyond the headline of banning TikTok or forcing the sale of TikTok. What's happening right now is that we are considering what a hate speech exception to the First Amendment would look like. In reality, I'm not even sure that the institutions are going to be able to adequately educate the public in the future. How are professors supposed to even talk about this moment in particular, Norm? How are students who are not alive right now or not conscious of the world around them, my son, right? How is he supposed to ever appreciate the gravity of what's going on right now? And especially so if the government is now going to use this Patriot Act 2.0, that is the bill for TikTok, to be invasive enough to be accessing personal Wi-Fi accounts and infiltrating every single communication that you might have, whether it's on your email, in your phone, etc. Right? I don't know that this hate speech exception really should be the focal point. I disagree strenuously that we should be considering it. I think that there's a strong argument to what I put on the screen a few minutes ago, a post on X from Mark Randazzo, who said that, these universities have endowments that total in the billions. Why is it the taxpayer has to fund cleaning up their mess? And I agree with that. This is a mess created by the institutions that are now crying about it. Personally, I think that these institutions should be left alone. We should let what's going to happen. And we shouldn't be using this as an opportunity to create more power within state and federal governments for people who are elected for other issues to somehow in the back halls of Congress or in the back halls of state legislature negotiate for deals that gives more and more enforcement power to the public safety sector.
I hear you, but what is the public? What is the public square? And is there going to be, or are there outer limits on what can and cannot be done in the public square? And if you create an enforcement mechanism, does it go too far? I mean, these are important.
And just so we're clear, I want to be, precise here. We've got two different bills that are being proposed. One right now is from a Republican out of New York, Richie Torres, or Mike Lawler, and then Richie Torres is the Democrat out of New York. They have introduced what's called the College Oversight and Legal Updates Mandating Bias Investigations and Accountability, the Columbia Act, right? Which would allow the education department to appoint a third-party anti-Semitism monitor to any college receiving government funds. Well, there you go. What college is not receiving government funds to some degree? The department would have broad power to set the terms and conditions of the monitorship, and the colleges would be forced to pay the cost of their own anti-Semitism monitor. Schools that don't comply with the monitoring would risk losing federal funding. And maybe that's the out. Maybe institutions that are serious about education should just opt out of the federal funding model. Because I've complained a lot on this stream about the cost of education being wildly disproportionate to the product that's being sold to students.
I hear you, and these are good points, and I'm reading the comments in the stream, and I just keep thinking, new wine, old skins. There's something bursting in the law's discussion of social reality, and I think the law is going to need to change for the sake of society. Not that the law needs to impose and sculpt society, but the law needs to change to accommodate these changes. I was part of a focus group last night that's preparing a case for a jury trial, and one of the questions the focus group leader asked folks is, where they go for news, and many folks go nowhere. They don't pay attention to the news, or they look at just a social media site, and so building a sense of collective consciousness is quite a challenge. It's quite a challenge. Dawn says, for centuries, we managed this socially. Yeah, that's fair. What changed? We are now open to the government monitoring and controlling our lives. Help. That's another good point. I think that, Dawn, what may have changed is the nature of the public. We didn't have social media. We didn't have 24/7 access to everybody's mind at all, who chose to participate in a highly artificial electronic forum.
Well, yeah, Norm, this appears to me to be some sort of war for power in the United States. It seems like there is a power vacuum that has been created by social media, and there's plenty to back this up, right? Our intelligence agencies were highly involved with formerly Twitter, Facebook, Instagram, etc. Google has been shown to have influenced and changed the way it operated in advance of the election in 2020. Got the Hunter Biden laptop story. But what we do know is that the established West politically has enjoyed an alignment culturally and otherwise with the Jewish state of Israel for a number of years. And the current paradigm in Congress reflects that. There is this loyalty and this duty inherent in Congress to Israel. TikTok exposed a fissure between the generations. The younger generation, Norm, does not recognize the merit of that position, the veracity of that position, and largely young people don't feel heard. To that end, we must ask what the true nature of why the TikTok is being banned, why control is being asserted over this. To me, this is a power game at a very high level to maintain the established order, to maintain the geopolitical alliances, to maintain the established private-public cooperation between governments, right? That at a very high level. And it's because the algorithms can be designed to suppress certain information, to limit its reach, to limit it from catching virality, and then encourage other things as well. And what we saw with TikTok is that the anti-Jewish sentiment was salient on that platform in the months and weeks after October 7th.
All right. Well, there you have it, folks. We've turned, or I've turned a corner, at least, with respect to hate speech, and in so doing, have held in relief a series of very credible concerns that all of you have about how this could be administered in a way that would be consistent with preserving other values that we hold deeply. This is what makes an interesting Supreme Court case. I mean, read pivotal Supreme Court cases and you will see that the justices who decide these pivotal issues that affect all of us deeply and require reconciling with other ideas in our history, why these decisions are so painful and why there are often not majorities, because reasonable minds can see it differently as we fight our way into the future. Now, and I think it is going to be a fight into the future, a conceptual fight, hopefully not a physically violent fight, although there has been physical violence in the United States.
The war is waging hot, Norm. It's already on.
As far as this podcast is concerned, our objective is to maintain norms of civility, to demonstrate how reasonable minds wrestle with complex issues, and to explore these issues from every angle, with the aim of building a community of people with the integrity to disagree on a principled basis and work to overcome those disagreements. So, thanks for listening in, folks. I don't know what the future holds, meaning, we're going to broadcast on tomorrow. But it seems to me that these discussions are absolutely necessary. And I think there's a hunger for them because we're trying to get beyond mimetic warfare. You won't hear us, I was really deeply disappointed in Alex Jones's feed yesterday. Mershon says that as a future sanction for Trump speaking, he may face incarceration. What's the headline, on InfoWars? Judge threatens to lock up Donald Trump, the Republican. I mean, come on. At some point, we have to get beyond sound bites and get to the conceptual and physical nature of the reality we're living in and ask, Mike for Secretary of Treasury, ask how it is that we're going to learn to live together. And, Mike, one of the things I really, really have come to value more and more, I didn't even realize this when we started, is the generational difference between the two of us. Because I am acutely aware, especially now that the pandemic is over and we're picking juries again, and I'm out there meeting and talking to strangers about how they perceive reality. I'm acutely aware of the fact that there is a broad intergenerational difference that in part reflects how we consume information, and that's one of the issues we need to deal with here.
Not only just consuming information, but our own habits and interaction with technology, right?
Yeah.
I think at a very hardware level as well. So yeah, Norm, I appreciate that. I think of all the motifs that we string together in this stream, I think that's the one that I cherish, is our ability to connect on that and explore that and unpack it. And I hope that the streamers, stream viewers, I hope that you all can appreciate that as well, because, family is very important. And these are conversations that I have with Norm, but I also have these conversations with my father and my father-in-law, right? And I'm searching for a way to communicate how to live a good life to my very young son. And so it's an important question to attempt to answer, is how we adapt as a culture in a very new era. So anyway, AMF yo-yo.
AMF yo-yo.
We'll see you guys tomorrow morning, 8 a.m. We're live 8 a.m. Monday through Friday on YouTube, on X, and on Rumble at Law Pod Daily. We also upload every single audio-only episode to Apple, Spotify, Google Play, Overcast, wherever you find premium podcasts. Please leave a comment after you like the video. Make sure you're subscribed, hit a notification bell. All of that is really helping us. And man, I love seeing so many active people in the chat every morning. Thank you to you all on all 3 platforms, X, Rumble, and YouTube. Norm, I'll see you in the morning, man.
You will.
Bye, everybody.